States. Hearing. The Court of Appeals of the State of Kansas is now in session. The Honorable Judge Hurst presiding.
Seated. Good morning, everyone. Welcome to the August 16th, 2022 morning session of the Kansas Court of Appeals. Today, we're sitting in Topeka, Kansas, and we're also streaming online. To my right is the Honorable Judge Steve Hill, who has served on the Court of Appeals for almost 20 years, after a few years as a district judge. And to my left is the Honorable Judge Gordon Atchison, who served on the court for almost 12 years on the Court of Appeals after a distinguished career in private practice. I am Judge J.C. Hurst. I've been on the court for just over a year after approximately about 15 years in private practice. Today, I'm your presiding judge, which means I have a few administrative tasks, and that includes that of timekeeper. Each party will have 15 minutes to present your case. Because we are streaming online, I will ask that appellants give a brief 30-second factual overview of their case, and I will start your timer after that. That will help orient the online audience to sort of what's going on. I'll remind the attorneys that we have read all of your briefs, reviewed the record thoroughly, and had a research memo regarding your case. So given the short amount of time, I would suggest that we don't dwell on the facts too much. Also, please be aware that we might interrupt you with some questions just for clarity and to get a better understanding of your arguments. With that, I will call the first case and ask that the parties enter their appearances. Case number 123687, the State of Kansas v. Joshua Sinnard.
Assistant Appellate Defender on behalf of Mr. Sinnard.
Thank you. Ms. Gunning, would you like to reserve any time?
Yes, Your Honor, I would like to reserve 3 minutes for rebuttal.
Don't mind. Please do a 30-second overview of the case before you start.
Yes, Your Honors. This case comes to this court after a jury trial. Mr. Sinnard was charged with commercial exploitation of a child. Prior to his trial, his case was continued multiple times, twice, both to accommodate another trial. At trial, there was evidence from the complaining witness in the case, as well as evidence of Joshua's cell phone records. Jury convicted him after that trial, and the court sentenced him to prison. He appealed from that conviction and sentence, and we are here now from that appeal.
Thank you. And so you have 12 minutes.
Unless this court directs otherwise, I plan to focus my argument on the first two issues in the brief, the speedy trial question and the issue regarding Detective Slither's testimony.
I do have a question for what I know you want to concentrate your argument on those first two, and that's fine.
Yes.
But I do have a question about your claim of instructional error. When I read that instruction, I see the definition of knowingly in that instruction. How can you claim to us that there was an instructional error?
I
Are you wasting our time, counsel?
don't believe that I'm wasting your time.
And how can you legitimately claim an instructional error when the definition of knowingly was in the instruction?
The definition of knowingly appears after the elements in the instruction. It does not appear anywhere in the instruction.
Oh, so
itself.
it's the placement in the elements that seems trivial, doesn't it, counsel? Is that really an error? Because it was read to the jury heard it, could understand it. It seems awfully trivial to me, counsel.
I don't believe it's trivial, simply because if you're going to have an elements instruction, even if you give the definition afterwards, the pick instruction itself, which everybody follows, does not include that knowing element.
Well, I don't care what's in the form book. You're claiming an error here in the Court of Appeals that there was an instructional error with an instruction that contained that. And unless you say the jury fell asleep or something like that when the court read that instruction to them, I don't see how we can proceed on that. That's all I want to say about that. You can go to your initial arguments. But I think in the future, if you're going to claim an instructional error and that information is contained in the instruction, you're on thin ice again. Thank you.
Noted, Your Honor. I would, as I said, I would like to start, I would focus on the first two issues in the argument. And unless the court directs otherwise, I would submit the remaining issues on the briefs, subject to the conversation I just had with Judge Hill, which I still maintain there was error in the instruction. I would first start with Detective Sliffer's testimony. In the brief, I put two separate issues. For clarity, I would say that we have first the argument that Detective Sliffer's testimony was not lay testimony. His testimony about the cell phone data qualified as expert testimony, but he was not qualified as an expert.
The district attorney asked him a lot about his background, and he did all kinds of stuff for the feds at some agency and had hours and hours and hours and hours of training on computers and cell phones and all that other stuff. I mean, it may not have been the most effusive discussion of qualifications, but in reading it, it sounded like it was sufficient to qualify him as an expert. Do you disagree?
I do, yes.
Why?
First, because our statutes require that there is a qualification process, and that the state specifically said that they did not believe that it needed expert testimony and they were not submitting him as an expert.
Well, I understand that that's their submission, but the assistant DA went through a bunch of qualifications with the guy that sure made him sound like an expert to me. Whether or not he was they were intending to offer expert testimony. I mean, they qualified him as an expert, it sounds like to me. And I mean, you're saying that what they went through wasn't sufficient to do that.
I don't believe so. I think
I mean, what else should they have done?
I think there is a difference between talking about qualifying someone as sufficient. I mean, you have to go through the qualifications for any witness to testify about anything. Even lay witnesses have to be qualified. What they qualified him as is a person who could testify about reading these cell phone data records. He is not a person, as we see through the cases, as we see through Fleming and Smith Parker and Timley and the out-of-state cases. He is not a person who is trained or qualified to talk about how cell phone data, cell phone technology.
He testified he was. He had all of this training in this, that he worked for this federal agency doing exactly that kind of stuff. How is that not training and experience that qualifies him to do that? Now, it may be, if one drilled down, that he really wasn't all that qualified, but just reading the testimony, and it was unchallenged. I mean, nobody disputed that testimony. It looked like
about his training and experience.
Right. And the prosecutor may have thought they didn't need to do that, but it's there and it's in the record. I mean, we can't really ignore that. But you're saying what they went through wasn't sufficient to qualify.
No, I would maintain that they did not present sufficient evidence to qualify him as a witness, as an expert witness, to talk about how the technology and how the actual hardware, how actually cell phones work. He is not, while he has done work and he has read cell phone data records, he has submitted requests for them, he has testified about them a lot of times. He's been to some trainings about how to, do things with cell phone records. He is not a person who can talk about why cell phones work the way that they do.
Did he say why, or did he say how? There's a big difference. One's theoretical and one's practical. Wasn't his testimony basically the closest, the strongest, all of those things that you see in Timley?
I think that he went further than that. He testified about the things that could cause disruptions and why a cell phone would connect to one tower over another based on geographical things. He further
Is there any
tested.
objection to any of that? So is any of this preserved?
I would maintain that there are several places.
There were two objections
Yes.
that I could see,
Yes,
and none of it was to that. One was sustained.
one was sustained. Yes, and so I would say that I mean the pretrial argument does get to some of that, but the other thing that he testified about is how why particularly it would not connect, why there wouldn't be any records for that period of time between a connection to the Tonganoxie Tower and a connection to the Legends Tower. And I think that went further as well. I also would say that he, I guess, I would just maintain that he was not qualified as an expert. The judge specifically told him to not go beyond the expert test, go beyond these things. And then there were objections, some of which were sustained. And so that even the court was not viewing him as an expert qualified to testify about certain things.
I'm very interested, if you could move on to your hearsay component of your argument there. I'm intrigued by the absence of a record as proof of something. And he testified that he looked at these records for 2 weeks before the date in question and 2 weeks after.
Yes.
On the defendant's phone records.
Yes.
And he said there were no, I guess we use the term pings, no pings on the Tonganoxie Tower.
Yes.
What's the problem there? From your viewpoint, what's the problem?
Well, I mean, we would start with what he introduced, why he was talking about that. So he said that in his course of business, he looks at records on either side of the incident that he's actually supposed to, asked to investigate. And he looks at that in order to determine if there is a pattern of behavior, or if there is a lack of pattern of behavior. And so in this case, he looked at the records on both sides in order to determine if there was a pattern of behavior of Josh going to Tonganoxie or not. And so,
is that inadmissible for some reason?
The objection that was made and that I've furthered in the brief is that is, if we're going to be talking about those records that he was looking at and that there was, that he was not presented to the court to really verify what he had said, his testimony based on those records are hearsay.
I'm trying to understand then, your argument is because those records for 2 weeks before and 2 weeks after were not admitted, then he could not testify about anything that was not in them. Is that your objection?
I think, I believe that the objection to the testimony is that if you're going to be testifying about those, we need to have some sort of verification of those records as legitimate, as passing the concern about hearsay. And so if you bring them in and you say these were created in the normal course of business and you have evidence that they are something that he's, able to rely on, that without that sort of getting over that hearsay hurdle, I don't think that he can testify about those records.
I'm sorry.
You think the testifying to the content of the records by testifying that something wasn't in them, he is then also testifying to what is in them?
Yes.
Well, isn't it kind of like testimony that the dog didn't bark? You still have to have testimony that there was a dog to begin with, right?
I would certainly hope so.
Okay. And that's basically it, is that what makes his testimony relevant wasn't admitted, or was inadmissible hearsay.
Correct.
Okay. In the greater scheme of things, why isn't that harmless error in this case? I mean, there's a whole lot of other stuff that tends to corroborate the victim's account. It seems to me that that's the tail wagging the dog, to continue with the canine analogies. But why is that a reversible error?
I guess what I would say, I mean, the reason I put these two together, and obviously one can be error and one cannot, but is because of the importance that the state placed on these cell phone records in order to bolster the credibility of PF in this case. And so Joshua's maintained he did not do the acts that were alleged in this case. He did not do them. And so in order to verify her account, they went to his cell phone records. And so I would say that it's not harmless error, because it combines to say, well, she was telling the truth. He went to Tonganoxie on this day. He doesn't ever go to Tonganoxie. He went to Tonganoxie on this day. And so we know that she's telling the truth. And so I don't think that they can
your
say
time. I apologize for the noise associated with it. I do think we asked a lot of questions and took up a fair amount of your time, and it seems that you did not address the speedy trial argument.
Yes.
In that, did you want to give a minute to that, given our?
I would just say that for the speedy trial, I think there was some confusion in the briefing that the question is, first, did the court abuse its discretion by granting the continuance? And I would say that the court did abuse its discretion by granting the continuance from the October 28th to the November 12th date. And then that movement beyond the speedy trial time that he had waived effectively violated his statutory right to speedy trial. And so those two questions would be what I was getting at in the brief, that the court abused its discretion, and then because of that, his speedy trial rights were violated, and so that this court should vacate his convictions because of that.
Is it your contention that any movement past that date is an abuse of discretion, even if there was a crowded docket?
At that point, I would, I think that again, it's very, very fact oriented. And in this case, the reason that it was moved, he was already second up on that date, which I understand is a concern, but he was not waiving his speedy trial and they put him second up. And so I would say that, yeah, an abuse of discretion. If the court had granted the first continuance because of the crowded docket, it couldn't do it again. In this case, they put him on a crowded docket knowing he was out of speedy trial time. And so I think that could contribute to finding any continued movement beyond that. Yes.
Any other questions, judges? You have 3 minutes remaining. Counsel?
Good morning, Your Honors. Unless the court directs otherwise, I do plan to submit the mistrial issue, the jury instruction issue, the Gregg evaluation issue, and the cumulative error issues to the court on the briefing. And I would like to start with the speedy trial issue.
Well, I'm going to have to ask you, since I asked your opposing counsel about it.
Mhm.
Is that erroneous? Was that instruction erroneous? Because it wasn't the definition of knowingly was placed at the end of it instead of higher up in the instruction?
Yeah, well, Your Honor, it's the state's position that the instruction was not legally erroneous, that it informed the jury of all the legal requirements to convict Mr. Sinnard when it laid out the elements from the statute, and then directly after those elements on the same page, it advised the jury that I believe I have the language to the state. Advised the jury that the state must prove the defendant committed the crime knowingly, and then it defined knowingly.
Where's the error there, counsel? If you tell the jury, look, you must find the defendant acted knowingly. Seems to me pretty well complies with the statute, doesn't it?
It seemed to me that way, and
Thank you, Counselor. You could go on to the rest of your argument. You've
Well-
satisfied my questions.
returning to the speedy trial issue, then I think in this case, well, admittedly, I think it was a bit unclear to the state what exactly the contours of the argument were. But I think it's clear here that the technical requirements of the crowded docket exception were satisfied. You know, the court granted a single continuance of not more than 30 days. It did so before the speedy trial deadline expired, and that it made findings on the record that other cases crowded its calendar, so it couldn't schedule the trial before that November 12th date.
Well, I think the argument partly, though, is that the judge created his own crowded calendar by moving another case to that same time and essentially giving it a priority over this particular case. And that's a manufactured or artificial crowding of the docket that shouldn't qualify. That's what I mean, sort of the gist of the argument I get from the appellate defender. Well, I mean, what's your response to that?
I'd say I have two responses, Your Honor. The first is obviously that as a factual matter, there was always a case ahead of Mr. Sinners on that same docket. So
You had no expectation of going on that day anyway. Is that what you're saying? Because he was second up after what, Perth or what?
that's the state's position that another criminal case, Potts is how it's referred to in the record,
Gotcha.
was always scheduled ahead of Mr. Sinners on that date. But to the sort of claim that the court couldn't move Ross to that date and then rely on Ross to invoke the crowded docket exception, I just think the court should look to its decision in State v. Dean. And there, Dean had argued that the district court improperly granted a crowded docket continuance because the docket crowding case was in fact a civil case that the court could have rescheduled. He urged this court, I should say, to read the crowded docket provision as demanding that the district court prioritize scheduling his criminal case over that civil case. And this court rejected that interpretation or rejected that reading of the statute. It determined that no language in the statute showed that the legislature intended for other cases to be limited to only other criminal cases.
Well, what about the circumstance, say the judge set 5 or 6 cases for that same day, October 28th or whatever it was, and put Sennard's case at the bottom of it, knowing full well that it was very unlikely to be reached at that point. I mean, is that fair?
Well, I think the statute, I mean, it's not violation of the statute. If that was the 180th day and he was scheduled for trial that day, and for whatever circumstances the trial was not able to proceed, the statute allows the court to extend the time for trial 30 days. And the reason again, pointing to Dean, the reason I say that is that the only criteria that the statute provides is that the case be pending for, or given its ordinary meaning, awaiting trial. And in this case, Ross was a case awaiting trial that prevented the court from trying Mr. Sinnard.
But only because the judge already set Ross. I mean, they moved Ross to that date. I mean, that's why it prevented it.
Well, again, I don't think the crowded docket provision requires that an assessment of the reasons a case, is the reasons a case cannot proceed because of other cases. I think it
So
just gives the court that discretion.
So the state's position would be that the judge can create a crowded docket and still rely on it.
Well, I think that's what judges do as an ordinary matter anyway. They have to schedule multiple cases on the same day. And I think it's an arbitrary distinction to draw to say that the court can't, if circumstances arise, the court can't adjust the calendar after the fact just because that calendar, was set at one point.
Because there's a statutory speedy trial requirement.
I'm not sure I understand the question.
You're saying that the court can overcrowd its docket despite the defendant's statutory right to a speedy trial.
I'm saying the court has a right to maintain its dockets, how it sees fit. So I think in this case, it's clear that the court, every docket the court had was essentially crowded. But I think, again, Dean suggests that, I mean, if a court can schedule a civil case where there are no speedy trial rights at stake over a criminal case, and certainly what the district court did here was no error.
Should docket management be left to the district courts, or should we hear from the on high on the second floor of the Judicial Center manage trial dockets?
I think it's going to surprise you that I don't believe this court should second guess the district court as far as its scheduling discretion and maintaining its own calendar. I think this case proves the difficulty of going back after the fact and trying to make a comparative assessment of all the cases going on at the district court level and what the district court was facing.
Actually, I think the decisions get made across the street in the Capitol where hardly anybody is a lawyer, but that's besides.
And that's certainly something that I guess it's for the district court to
Be recorded. I guess I shouldn't have said that.
I'd like to briefly turn to the issue regarding the detective's testimony.
Was he qualified as an expert?
The state asserts that he certainly was. In this situation,
I guess I should say he has qualifications that would make him an expert. Did the testimony elicited from him by the assistant district attorney qualify him as an expert?
if you're asking whether the state asked the court to make the determination he was qualified as an expert, that didn't occur in this case. As the state argued below, it was its position that the testimony did not require him to be qualified as an expert because it was matter.
But let's presume the testimony did qualify him, but just to be an expert. Let's say he went outside of the bounds. Do you think the state was required to identify him as an expert and provide additional information in order to qualify him as an expert that was not provided?
I guess I'm going to have to maybe ask you to first for some help here, but the way I understand the record, I mean, I guess it's the state's position that he was qualified. He didn't exceed those qualifications in his testimony, but assuming that to be the case, which I believe is your question.
My question is yes. Let's assume we all think he went beyond the layperson testimony.
Well, beyond the layperson testimony or his own qualifications?
Well, beyond the qualifications that he was not an expert, so that he went into expert testimony. Is it your position that the state did not need to identify him as an expert to give those?
Well, I think, again, this gets to some of the confusion regarding the issues, because I know, I guess the issue was sort of framed as a failure to designate, but that wasn't exactly the way it was argued. There was an authority, there's no authority cited as far as like the provision that requires the state to disclose. There was no discussion as far as how the lack of notice impaired Sinard's ability to defend himself against this evidence. I mean, I think the fact that trial counsel raised the issue about his testimony before he even testified shows that they were anticipating that this was a subject matter that the detective might discuss.
But the trial court ruled that that pretrial procedure didn't make a finding that he was an expert, but told defense counsel if he exceeds something, object. And if I'm reading the record correctly, I see two objections. One was sustained.
That was my understanding, that there were two objections made based on the argument that his testimony could be expert testimony. And the first was sustained. And again, though it was sustained, I believe the record shows that the testimony wasn't, in fact, didn't really address the sort of subject matter that would qualify as expert testimony under the arguments here. But the second objection that wasn't sustained, again, was the sort of general testimony this court has approved in the line of cases from
Well, Timley.
Well, Tim Lee from the Supreme Court, and then this case in Smith, Parker, and Fleming. Because it was essentially cell phones generally try to connect to the tower with, or cell phones try to connect to the tower with the strongest signal. Generally, the biggest factor in that is distance, but there are exceptions for physical or electronic interference and load balancing, that sort of thing. And I don't think that's anything that a layperson can understand.
Well, it's not a question whether they understand, it's whether they know it or not, isn't it? I mean, it's whether it's an expertise that will assist the jury in understanding the circumstances, right?
Yeah. Yes, Your Honor. And I would submit again under the line of cases that we have here, and maybe this isn't, not. I don't believe that this is information that surprises anyone these days.
Now, I think that the ADO is drawing a distinction between the testimony about how and when a cell phone connects to the nearest tower, and then the testimony regarding disruptions to the tower connection. Is it your contention that the sort of layperson being able to testify that a cell phone connects to the nearest tower is the same as testimony regarding disruptions to that, and what causes that to occur?
I think so. I think that testimony that cell phones connect to the nearest tower is inseparable from the testimony as far as other things affect that. But as far as specifics about what might have interfered with signals in this case, that would be expert testimony, and that was not provided in this trial. That topic was never discussed.
Well, all of his testimony concerning this was in general terms, wasn't it?
I do believe the only specifics were when Detective Slifer spoke about the details from the call records themselves.
The details were concerning the record, and
Right.
one record was admitted. We even have that in the record. All of this other was general information that he gave the jury. None of that was any details. Did he? Did he ever say why something happened?
I don't think he ever said why anything happened. My understanding of his testimony was he said why things could happen. He never said why anything happened in this case.
You have about 45 seconds.
I guess unless the court has any remaining questions, I just submit the arguments to the court as they've been written.
No other questions? Thank you, counsel. 3 minutes of rebuttal time.
I would like to start with Simpson's argument that this is a complaint about his qualifications as an expert, not statutory complaint in disguise. It's not, because he was never qualified as an expert. The state never tried to even follow through the procedural remedies, the procedural safeguards for that. And he was not found to be an expert. And so that's not the issue here. It's whether or not he was able to testify as an expert without having been qualified as such. If he went beyond the bounds of lay witness testimony, which means that he was giving, lay witnesses cannot give evidence that provides inferences or opinions to the jury about how they should view this technical evidence. And that is exactly what Detective Slifer apparently did in this case. Moving to the speedy trial issue, I would strongly distinguish Dean. In this case, this is not normal routine docket management. I'm not asking this court to put its thumb on the district courts and manage their dockets for them.
Well, what did the district court do wrong? You said it abused its discretion by moving one case, the rape case, onto the trial date where your man was second up,
Yes.
still second up.
He was still
And the
second
rape,
up.
had the rape case not gone, he would have been tried then, but they bumped it because the rape case was going.
I don't.
So how is that abuse of the court's discretion? Tell me that.
Well, I think that, I mean, there's definitely a big problem in the first place with putting him second up, knowing that he is at the end of speedy trial time and that he's not going to waive any.
But when he got that date, he knew it was second up.
Yeah, and
he
he, I
agreed
mean,
to it.
I think that
He
we would
agreed
be,
to it, didn't
we
he?
would definitely be in a different scenario if he had not agreed to that, because then the court would have had to rely on on the crowded docket to move him in the first place and then could not move him again. But I don't think that that's, I mean, I don't know what would have happened to Potts. What we are told is that Ross had priority over over Josh's case.
It was an
At
older case than this case,
Okay.
correct? Week-long trial, more severe penalties involved than your case. And the court put it there. Again, how is that an abuse of discretion? The court had responsibility to try the Ross case too, didn't it?
Yes, and I think, I mean, when we're looking at Dean, if we're balancing civil and criminal cases, and we're saying that civil and criminal cases, we're not going to prioritize one over the other. I think we always have to talk about prioritization. In this case, we had two individuals who were out of custody, one of which who was not willing to waive his right to speedy trial, one of which who had already agreed to move his case to the next February, and the court, with the assistance of the state, said, well, let's move him to this date. We'll just have to make that finding that you need to make in order to move Josh's case as well.
The argument is because the other defendant was willing to waive the speedy trial.
I think that's a big
That
part of it.
distinguishes it from Dean.
I think that's a big part of it. In criminal cases, when you're comparing two criminal cases, and I know that the state referenced the amendments of the statute, one of the things that you do have to consider is that both of these people have speedy trial rights. That the rights and the rights that we're balancing are not the state's right to try a case when they want to try a case. And I know that the court does have responsibility to manage its calendar, but it is a responsibility that it holds, and to manage that well while respecting the rights of individuals who have speedy trial considerations.
I would suggest you move on to closing up the.
And so again, I don't think that this is asking the court to put its thumb on the Douglas County District Court or any district court in this case in the state. Speedy trial is always a case-by-case factual scenario analysis. And I think in this case, the court abused its discretion by moving Josh's case a second time to accommodate Jordan Ross's case. And so for that reason, I would ask that this court vacate his convictions for violation of his statutory speedy trial rights, or in the alternative, based on my other arguments in the brief, reverse his conviction and remand for new trial. Thank you.
The next case is 12416 and 124017, State of Kansas v. Garrett. Council all present? You could state your appearance.
Juan Garrett appears through counsel, Casper Shire, Kansas Appellate Defender Office.
You.
I'm Shannon Grammel, Deputy Solicitor General on behalf of the state of Kansas.
Terrific. Thank you. Yes, thank you. That's fine. Okay. Mr. Shire, do you want to reserve any time?
3 minutes, please, Your Honor.
And if you don't mind, like I asked in the prior case, could you give a 30-second overview for anyone watching?
Absolutely, Your Honor. This is an appeal from orders extending Edwanda's probation in two separate district court cases. One is a 2007 case, one is a 2016 case. Needless to say, her probation has been extended a number of times in that period. Some of those extensions have been because she's been unable to make restitution payments. And it's our position that that violates the equal protection and due process clauses of the United States Constitution.
Fantastic. Okay, you've got 12 minutes.
Thank you, Your Honor. The length of a probation is typically capped at 5 years by statute in Kansas. But Edwanda has been on probation since 2009 because she's been unable to pay court-ordered restitution. Yes.
I've read the brief. I get the facts. What I don't get with a lot of clarity is the class that you believe is disadvantaged under the Equal Protection Clause in this circumstance. Could you define the class specifically for me?
The Griffin line of cases that we are basing our argument on, Your Honor, tells us that in cases like this, where the right of indigent persons to access criminal justice is at issue, it's not just an equal protection problem. It's an equal protection and a due process problem. And those types of cases need to be subject to robust scrutiny by this court. So
the equal protection case, what is the class and indigent defendants?
an indigent defendant seeking equal access to criminal justice.
Okay, I'm not sure what that adds. I mean, obviously, if they're seeking access, or we wouldn't be listening to them, but.
Well, I think there's a lot of case law, Your Honor, that says there are two areas that need to be treated differently in the equal protection sphere. Those are the right to vote and the right to access criminal justice. Bearden states this very clearly. The ACLU in its amicus brief cited a number of lower court decisions that have said, yes, when we're talking about access to criminal justice, even if indigency is—
What is the access that Ms. Garrett is being denied in the criminal justice process?
KSA 216608C7 is setting up a two-tiered system of justice. It says that if you cannot pay your restitution, your probation can go on forever, as long as the state and the district court see fit to continue it. If you can pay off your restitution, you are statutorily entitled to discharge after 5 years. The court—
What she's seeking access to that is being denied is discharge of her probation.
Yes, Your Honor. The evil that we see, the constitutional evil—
Well, and that's based on her, and what you're saying is that's based on her indigency.
Yes, she is unable to take advantage of the 5-year cap on probation because she has been unable to make her restitution payments.
Okay, so is the class indigent defendants then? Or is it something narrower than that? Or is it something broader than that?
I suppose the class is indigent defendants, Your Honor, with a caveat. And the caveat is, when we're dealing with basic access to criminal justice, which is exactly what we're dealing with here,
I get that.
that needs to be treated differently.
All right, but indigency means being poor, essentially. Are you saying, this may be a narrow group, but are you saying that she is similarly situated to someone who chooses to be underemployed? I mean, the classic starving artist, the person with a medical degree who decides they don't want to practice law, and they paint not very good portraits and don't make much money.
No, Your Honor.
Entitled to the same benefit because they're indigent as you're wanting for her?
Arguably, they're not, Your Honor. And I would point—
and that's what I'm trying to get to is I want to understand what the class is, or the group that you say is disadvantaged. And we started with indigency. Now you're saying, well, it doesn't include starving artists. What is the group?
I'm not exactly saying that it doesn't include starving artists.
What are you saying?
I'm saying, Your Honor, and I think the question, the case that I'm going to point to answer your question is Bearden. And Bearden is about incarceration,
Right.
Incarceration for non-payment.
Yes.
There has to be a finding of willfulness. There has to be a district court finding that non-payment is willful before the court can impose incarceration for non-payment.
Okay.
And I think that's exactly what this scheme is lacking. Here, there is nothing that says Edwanda's non-payment has to be willful. before the district court can rely on it to extend her probation.
There's nothing in the statute that says the court must make a finding why they haven't paid.
And I think I think if that was in the statute, we might not be here having this argument, Your Honor, because I think that would go a long way towards solving the problems.
So
that
what
we
you're
see.
saying is indigency is maybe not the class, because if there needs to be a finding of willfulness, then even the perhaps person who chooses not to work, who cannot pay, could have forever probation. But what you're saying is that maybe your class is different than that, not just indigent, but perhaps something else.
I think certainly the court could look at the issue that way, Your Honor. I think there,
We want to look at the issue the way you are presenting the issue to us.
I understand, Your Honor. And one of the difficulties in raising an issue like this one, is that a lot of different courts have analyzed it in a lot of different ways, to be quite honest with the court. But I think they are a lot of trains going to the same station.
We're just trying to figure out what the sign on the station is here.
The fundamental evil, the fundamental constitutional evil that we are objecting to, and objecting to strenuously, is that the statute is setting up a two-tiered system of justice.
Based on ability to pay.
Based on ability to pay. Yes, Your Honor. We have one form of justice for people who have the ability to pay off their restitution, and one for those who
And
can't.
the adverse impact or effect on Ms. Garrett is the loss of principally the right to vote, correct?
The loss of the right to vote is certainly important, but that is not all. Beyond the loss, there's obviously the right to equal protection of laws, the right to due process, but beyond that, there's the right to serve on a jury.
Well, I understand that. I mean, there are other collateral effects of it. I mean, I suppose principally in my mind is the right to vote, but I mean, there are others, and that's what you're talking about. I mean, that is a very real and significant detriment to her because she's been on probation for 10 years because she can't pay off the restitution.
Yes, Your Honor.
And you're saying that's unfair.
Yes,
Okay.
How about having to report to a probation officer for the rest of your life?
that is a restraint on liberty, and our Supreme Court has recognized that. And that's a restraint on Edwanda's liberty that is going to continue potentially for the rest of her life because she doesn't have the resources to pay off her restitution.
Are there other restraints on probation, constitutional restraints, First Amendment restraints, that sort of thing?
Yes, among them, the Kansas Constitution guarantees the right to be free from debt-based imprisonment. This essentially allows the state to keep the specter of debt-based imprisonment hanging over Edwanda's head for the rest of her life. Down the line, she might be revoked for, missing payments or even committing a new crime, if that's something that happens. I'm not suggesting that it will, of course, but when the basis for the extension in the first place was because she didn't have the resources to pay off her restitution, that is functionally debt-based imprisonment. That is what Edwanda is being subjected to.
Now the state I'm sorry, go ahead, Judge.
In putting together your brief and arguing this issue, did you consider something that's known as the Anderson verdict balancing?
I don't believe I did, Your Honor.
Okay, so I mean, you don't know whether it applies or doesn't apply. I mean, it's something you didn't consider and reject as inapplicable.
No, I did not.
Okay.
I'm not familiar with it, to be perfectly honest with the court. If you would like additional briefing, I'd be happy to provide it.
If we want more, we'll let you know.
Thank you, Your Honor.
I just wanted to know whether you had looked at it and rejected it for some reason, and you haven't. That's fine.
The state argues that it's allowed to restrict felons' right to vote. Therefore, this would not be, her inability to vote while on probation would not be a fundamental right that qualifies for this. Can you address that argument?
Sure. I think the fundamental problem is the same. Can the state restrict who can vote and who cannot after a felony conviction? Sure. Can they create a two-tiered system where people who can pay off their restitution are able to get reenfranchised and people who cannot are not? No. It's the same fundamental problem, Your Honor.
And you think they cannot create that two-tiered system even if the class is indigency?
Yes, and that goes all the way back to Griffin. Griffin says that the state cannot create a right and then make a right in the criminal justice system and then make access to that right dependent on somebody's ability to pay. That is precisely what the statutory scheme does.
Let me ask you, shift gears here slightly, looking at an equal protection issue. Let's take someone who has been sent to prison and is on post-release supervision, okay? And someone on post-release supervision can be required to pay restitution. And post-release supervision is set on the by statute. I mean, it's 12 months, 24 months, 36 months typically. If you know what happens to a person who is on post-release supervision, has not paid off the restitution, can their post-release supervision be extended for that reason?
To the best of my knowledge, it cannot. I don't know of any statute that would allow that, Your Honor.
Well, I don't know either, and that's why I'm asking. I was wondering if you might have run across that.
To the best of my knowledge, the answer is no.
What happens to the unpaid restitution when the person gets to the end of their post-release supervision? Does it just evaporate?
I don't know that it evaporates, Your Honor. I think that's a very good question, particularly in wake of the recent Arnett decision. And I almost hesitate to bring this up because I know I did not brief Arnett, so I apologize if I'm stepping too far. But I think.
Okay, do you know whether someone in that situation, they get to the end of the post-release, they've satisfied their sentence other than there's this unpaid restitution, can that person then vote?
As far as I know, yes, Your Honor.
Is there some rational basis for the drawing a distinction between someone on post-release supervision and someone on probation like that?
I cannot think of one, Your Honor.
You have just about a minute.
I'll just conclude by renewing all the arguments that I made in the brief, by endorsing the arguments made by the ACLU, who, again, I think are asserting a lot of the same fundamental principles that we are, maybe getting to the station in a slightly different way. But the fundamental problem here is that we've got a two-tiered system where people who can pay off their restitution are treated better than people like Edwanda who can't. We ask this court to find that scheme unconstitutional and to give Edwanda relief from another.
You're characterizing people who can't as not people who choose not to by choosing not to work or whatever, but people who under certain circumstances, for example, disability, cannot.
Correct, Your Honor.
Thank you very much.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the court. My name is Shannon Gramble, and I represent the state of Kansas, which is the appellee in this case. For the first time in this court, Ms. Garrett argues that it is facially unconstitutional for the state to require someone to complete the terms of their sentence. And of course, here we're dealing with a restitution payment before they exit probation. That argument should be rejected for two reasons. The first is that Ms. Garrett did not raise this argument below. This is the first time the argument has come up is in this court on appeal. It's not preserved. The second reason is that the argument has no merit and is foreclosed by the Supreme Court's opinion in State v. Gordon. I'm going to start with the merits of the claim. Ms. Garrett's argument is squarely foreclosed by the Kansas Supreme Court's opinion in State v. Gordon. So in State v. Gordon, the question there was whether the 14th Amendment requires a hearing before the extension of probation. And the argument made by the defendant in that case was based on Bearden. And we have this Bearden line of cases that says you can't imprison someone based on their inability to pay. What
Did the court in Gordon consider the impact on voting rights?
Not in its opinion, but of course that is part of the statutory scheme that when someone is on probation under Kansas law, they do not have the ability to vote.
Is Gordon controlling then if the issue is the denial of a fundamental right to vote?
So two responses to that, Your Honor. Gordon, of course, is Kansas Supreme Court precedent and has said expressly that the Bearden line of cases does not extend to extension. My second response is that the statute that is being challenged here is not the statute that says that people on probation cannot
They
vote.
work hand in glove.
But if that's really the deprivation of the right to vote is the issue, that's the statute that deprives somebody of the right to vote. Keeping someone on probation, that's what's at issue here, is extending a term of probation.
The legislature knows that's what the impact of it is. And you read the two statutes, and again, they work together. You can't separate them out that way, can you?
And the Kansas Supreme Court would have been aware of that as well in State v. Gordon. And what they said there is we don't have the same sort of.
But was the issue even raised in Gordon?
Your Honor, I haven't read the briefing. I'm not sure whether the parties
Well, the court
specifically.
certainly didn't address.
The opinion did not address, you're correct, Your Honor, the court. did
Well,
not.
and that's what we go on. I'm not sure I understand how it's, I mean, it may be analogous and could be extended to this issue, but it doesn't resolve the issue of the impact on voting rights, does it?
Correct. What the court said in Gordon, but the holding in Gordon is that this statute here, the statute extending probation for failure to pay, Bearden doesn't apply to.
Right, but the argument wasn't raised and considered.
I'm not sure it wasn't raised, Your Honor, but I do take the point that it's not mentioned in the case law. But I do think there are still less, even if you find the Gordon, I believe Gordon is controlling, but if you disagree, there are lessons learned from Gordon that courts have
Before we get to
applied.
those lessons, does the Anderson verdict balancing doctrine apply here at all?
Your Honor, I also did not engage with the doctor in my preparation. I apologize. But it,
Well, it wasn't raised. I mean, I'm just asking whether you have an opinion on it. If you don't, that's fine.
I'm sure I do. Would you remind refreshing me of the balancing test, Your Honor?
Well, I'm not hugely familiar with it. I mean, it's applied in voting and ballot access cases. It's based on two U.S. Supreme Court cases, Anderson versus Celebrezze and Burdick versus Takushi. And it applies a less rigorous test and strict scrutiny, but a stronger test than rational basis for various restrictions on voting and ballot access.
So-
And I didn't, because it hasn't been raised, I didn't go exploring it in great detail. I don't know for sure whether it's applicable or not. And y'all are supposed to guide us, and I'm asking for some guidance. And it's kind of like the station that doesn't have a name on it. So
Of course.
that's
Your Honor.
fine. And I don't want you guessing or speculating. If it's something you're not familiar with, that's fine.
No, I do have two responses. I think, first off, not to belabor the point, but the fact that it wasn't raised is telling that voting, this isn't the statute that's implicating voting rights or taking away any sort of voting rights. My second response, and I think defendants counsel said the state is allowed to restrict the access that felons have to voting.
Well, clearly they can do that, but can they do it in a way that fences out people because they're impecunious?
So the court can't do it arbitrarily. I think what's important to remember too is Ms. Garrett isn't on probation because she can't pay. She's not on probation because she doesn't have money. Her probation is part of the sentence of her crime. That's also why she's paying restitution.
Well, that's why she still is. I mean, it wasn't why she was originally.
Sure.
and it is
Wasn't a
now.
10-year original.
Of course. But it is,
Let's not be disingenuous about the.
I don't
reasons.
intend to be disingenuous, Your Honor. I apologize. I think she was aware at the time that restitution, she was sentenced to restitution that could be extended for a failure to pay. She knew the amount of restitution. She knew the payment. So I do apologize. I do not intend to be disingenuous. But I also think there's an important distinction to be drawn between the fundamental right to vote, period, and the right of felons to vote and access to the ballot on that front. And what you have when you have, there isn't a fundamental, the case law says that there is not a fundamental right to vote for felons. Now, the state may not arbitrarily distinguish between people with no good reason. But I think there's the Jones versus Governor case out of the 11th Circuit recently, where the court held that the state does have a reason to people who have not finished the terms of their sentence, including restitution, to wait to restrict the right to the ballot for folks who have yet.
That would be persuasive authority for us.
Of course.
And it's long and involved, and there were dissenting opinions in that as well. And those would be persuasive authority if we choose to follow those.
I understand, Your Honor, but
Would you, or could you address the circumstance of a criminal defendant who's on post-release supervision with restitution and has not satisfied that when he or she gets to the end of the term of the post-release supervision, and what happens?
Your Honor, I'm not entirely familiar with the post-release supervision schemes. I don't want to wade into waters I'm unsure about or speculate
Well,
there.
That's fine. I mean, he didn't know either, and I don't know. Again, I'm looking for guidance, and we have another station without a sign on it. So, okay, no, that's fine.
But turning back, I think the lesson to be drawn from Gordon is that the reasons Bearden gives, there are other cases that have applied Gordon to the statute. In unpublished cases, of course, would be persuasive, but they have found that this statute does not violate the 14th Amendment, does not violate equal protection, does not violate due process, because you do not have an immediate loss of liberty. You do not have the same sort of grievous loss of liberty as when someone is imprisoned. There is no suspect class at issue. There's a long line of Supreme Court cases saying there's no suspect class at issue when fines are required, when there are distinctions drawn based on money. And there just isn't the same fundamental right here that's at issue when you're imprisoning someone. So that's the State v. Bowling, where the same argument was raised. The court considered it and the court rejected it, feeling itself bound by Gordon to say that the Bearden line of cases doesn't apply. So I urge the court, following the same logic, Bearden does not apply in this case. You do not have imprisonment. The lesson from the Bearden line of cases is that the state cannot imprison people based on their inability to pay. Now, what Gordon says, it's not just a blanket, you can't imprison someone who hasn't paid. Gordon says you can't do that without findings, or not, sorry, not Gordon, Bearden. You cannot do that without findings. And the findings the court would need to make is about willfulness.
So let me see if I understand what you're saying. Because of this line of cases, the court here couldn't revoke her probation for failing to pay restitution.
The court would have to make findings that she had either willfully refused to pay or that there was not an adequate alternative.
It's been 10 years. Obviously, that's proof of willfulness. So
And
off she goes, right?
so, yes, Your Honor, and this case is an interesting posture because she raised an argument below that she did not have an ability to pay, and the court disagreed with that. The court said, you actually can pay the restitution. I understand that $50 a month might be a little high, so what I'm going to do is I'm going to reduce the payments. And you'll pay $20 a month on both of your cases. That's $40 a month total.
And
With what you make,
wait, $16,000, what, 40 years? Maybe she'll pay it off at that rate.
it's a long time, Your Honor. I think one thing that's important to remember here, this is a facial challenge, and there is a statute in Kansas that allows for restitution to be waived where it is unworkable. So when Ms. Garrett was sentenced to her first,
That only applies though when it's said at the beginning, doesn't it?
but State v. Heron says that you have to consider that statute hand in hand with the statute extending probation for failure to pay restitution.
We can consider those hand in hand, but we can't consider extending probation and the extinguishment of voter rights hand in hand.
I think the link is attenuated when you're talking about, if you're really challenging access to the ballot, you should be challenging the statute that takes away your access to the ballot. But I understand Your Honor's position that it is a consequence down the line. But in state, so it's saying part of the workability determination is thinking about how long someone's going to be paying. And so when Ms. Garrett was sentenced, she had almost $17,000, I believe, in restitution for her first convictions on a $50 per month schedule, which at the time, that's still a very substantial period of time. And to my knowledge, there was not a workability argument there. There was no workability concern. And the statute was available to be raised. This is the very first time that she has raised the workability concern. And the court found that she did have the means to pay restitution and to continue paying restitution, and worked with her to find a schedule.
Does restitution under that circumstance serve any useful purpose?
Which circumstance, Your Honor?
Well, that it's going to take, she's paying off $20 a month in each case, essentially to institutional parties that have been harmed, and it's going to take her 40 years to do it. Does that serve any rational basis that restitution is supposed to serve?
A couple of responses. There are still two important interests that are being served by paying restitution. Number one,
Enlighten me, what are they?
I do think, and again, it's a facial challenge. So in not all cases are banks going to be on the other side of this. There are going to be cases where payment, even in small increments, payments really matter to those who have had their money or property taken from them. So there's still the interest in ensuring that the victims of crimes are getting at least some part of what was taken from them. And I think there's another state interest in deterrence. If you remove the enforcement mechanism, that deterrence interest is substantially curtailed.
Then what's the deterrence to Ms. Garrett at this point? That she needs to keep paying for 40 years so she can vote in 2060 if she's still alive?
I think the deterrence interest is to keep people from committing other crimes that would involve other restitution obligations if they know that the probation is going to be extended further.
So it's to prevent Ms. Garrett from committing future crimes.
Not Ms. Garrett specific, but in a statute like this does work a deterrence mechanism to prevent people to.
And does this statute actually result in people paying off more of their restitution? Is the goal? So the goal of the statute would be, theoretically, the rational basis would be to get the restitution paid off. And so is it the state's position that that actually occurs?
Yes. And again, I think, again, facial challenge, but this is a good example. Ms. Garrett has paid back over a long period of time, paid back over $2,500 of her restitution. And my understanding is she's continuing to make payments. So payments are happening on the restitution. Money is being returned to the victim. So there is service of the state interest happening through the statute. And I think.
Now, let me ask you this though. Is there a probation officer then that she has to report to?
One of the terms of her probation is to report to the probation officer as reported.
And then there's court time as well. So the state's interest would be having the $2,500. There is a probation officer that is assigned to this case as well over the next 40 years, theoretically at a cost of more than $2,500. And if she did not pay, she could go to jail. For how long?
Well, I think it's important to remember that if she's facing a revocation of her probation, then the Bearden line of cases does kick in, and the court cannot send her to jail because she cannot pay. The court would have to find that she's willfully not paying, or that there's no alternative means.
So you do think there's a distinction then between an indigent person who is willfully not paying and an indigent person who is just choosing not to pay?
I think so again, I think Bearden is kind of.
I apologize, I misstated that.
I understand, John. I think Bearden is kind of, when you look at the Bearden line of cases, you see kind of this fusion of equal protection and due process that really isn't the standard way we think about the 14th Amendment. Bearden is the exception rather than the rule. And so the Bearden line of cases applies when you're imprisoning someone, when you have that sort of grievous loss.
I understand that. I want to get back to the class. We're agreeing here that Ms. Garrett is in a class of persons who are indigent but not willful, indigent and not willfully not paying, as opposed to the other class of people.
So a couple of responses to that. Number one, the court below did not find that. The court below found that she did have the means to pay her restitution. They found the restitution.
Wait, are those the same thing?
Sorry, she did have the means.
Okay.
I apologize if I missed. She did have the means, that she had the money from her Social Security and her income to pay her restitution, that she was not unable to pay. I think my second response is that the statute doesn't draw that distinction. The statute says people who have and have not paid. So on the face of the statute, you don't see a distinction between people who are unable to pay and people who choose not to pay despite having the ability to do so. And so I think the lesson to be drawn there is that sort of distinction. It's not implicating any sort of suspect classification. There's no race, religion, nationality distinction being drawn. You don't have the sort of fundamental right of interest in these equal protection cases. Rational basis. So State v. Bowling applied, said there is a rational interest in ensuring restitution is repaid.
Thank you. You have 30 seconds.
Thank you. I think the other more fundamental reason to reject the argument, Your Honors, is that it has not been raised. State v. McGee says there's no fundamental interest here. As in State v. McGee, there's also no prudential reason to invoke any of the exceptions to the preservation rule, because she has had opportunities over and over again to raise this sort of challenge to her probation, and she just hasn't. So for those reasons, Your Honor, I respectfully ask that the court affirm the orders of the district court. Thank you very much.
Questions? Thank you. And have 3 minutes left.
Thank you, Your Honor. I hope to make just a few quick points. First, the state insists that at this point, Edwanda is still protected from being incarcerated by Bearden. And that's certainly true, but Bearden does not protect her from being incarcerated for a missed probation appointment, for a simple failed drug test, for any number of technical probation violations, even though she's been extended far beyond the 5-year cap that would otherwise apply. Second, the state has a number of civil remedies to collect this restitution, and that becomes important in a number of the balancing tests at issue. In fact, the record shows that Edwanda has been engaging in those civil processes. She's had a bankruptcy case proceeding, which they've talked about on the record. The restitution debt is part of that bankruptcy proceeding. There have been garnishment orders filed, particularly in the 16 CR case. And that's probably a large part of the reason why Edwanda has made some progress towards paying off her restitution, even though it's going to take her probably another 40 years at the rate she's going to finish. Third, I think even if this court disagrees with everything that I've told you today, the state cannot even meet the rational basis, the rational basis review test. There is no rational basis for believing that endless probation is going to be an effective tool to collect restitution payments. First, because to be maybe more crass than I should be, you can't squeeze blood from a stone. No matter how much coercion you put on probationers who are indigent, you cannot make them part with money that they do not have. Second, as the ACLU did a very good job laying out in its amicus brief, probation actually makes it more difficult, and the restraints of probation make it more difficult to get the kind of job that would allow people like Edwanda to pay off their restitution debt. And third, if the state actually follows through and drops the hammer on Edwanda by placing her in prison, they are completely destroying her ability to make restitution payments. For all of those reasons, we do not even believe the state can meet rational basis review. Obviously, we think that this issue should be subject to much more stringent review based on the Griffin line of cases. And we ask this court to find the statute unconstitutional and to grant Edwanda relief. Thank you.
The final case on our morning docket is number 123931. Melissa Schrand, the Kansas Department of Revenue. Is council present? Please state your appearance.
Kansas Department of Revenue. I'm New Win on behalf of the Kansas Department of Revenue as the appellant.
Thank you.
Bruce Mayfield appears for the appellee, Melissa Schrand.
Thank you. Ms. Wen, would you like to reserve any time?
4 minutes, Your Honor.
Mind giving a very short overview before you begin?
Yes, Your Honor. May it please the court. This was an appeal from a district court trial on behalf of a driver's license suspension case. There were 3 settings for this case. The first setting was continued upon the appellee's motion for a continuance due to 3 officers that were subpoenaed didn't show. The second setting was continued due to COVID. The third setting occurred, and what happened at that setting is on appeal for today.
Thank you, Ms. Wen. Please proceed.
On the day of
Counsel,
trial-
I'm familiar with the facts and we'll get right into your argument if we could. It seems to me that you're arguing that since the burden in this district court proceeding is upon the licensee.
Yes.
You shouldn't be punished. The Department of Revenue shouldn't be punished just because your officers didn't show up.
Yes, Your Honor, that is my argument.
I guess if that's the case, why did you ask for a continuance the first time when none of your officers showed up at the district court?
I asked for a continuance because I had subpoenaed those witnesses and
But under your theory,
yes, and
since the burden was on them,
yes,
all you could go on the certified driving record and the copy of the, what is it, DC
27.
27. I kept wanting to say 72. And you could just submit that and there's your prima facie case, correct?
Correct, Your Honor. And I only subpoenaed these witnesses to supplement my case with some of their testimony that they would have testified to.
Right. And if
So
I
I didn't need
understand
to do that.
correctly, in this second trial, we'll skip over the COVID situation. The second trial in district court, or I guess the third setting, there was an agreement that you were going to subpoena these officers, and one of them did show, but two of them did not.
Yes, that's
And
correct.
they were both, all three subpoenaed, correct?
They were all three subpoenaed by the Kansas Department of Revenue, Your Honor.
And that was by an agreement with counsel for the other side, so they did not have to subpoena them.
I would argue that the opposing counsel did ask me if I would subpoena them. I stated I would. I had already subpoenaed two. I was going to go ahead and subpoena the third. For all three trial settings, I had already subpoenaed all three witnesses. And I would like to also state that on the subpoenas that I filed and had the clerk sign at the district court, all of them state that that subpoena is for that witness to testify on behalf of the Kansas Department of Revenue. It never stated that it was for both parties. It was pretty much a courtesy that I agreed that I would be subpoenaing those witnesses already.
So what should have happened in your view? What did the district court do wrong? When the council gets up and says, hey, two of these witnesses aren't here, I can't make my case without them.
I would say that the district court should have allowed testimony from the officer that did show and to allow both parties to present their cases. Here, no facts were taken into consideration before the trial basically started. The trial court went ahead and allowed or granted the motion to dismiss the case.
I was interested to see all three of these officers sign this certification. That's rare to me. I haven't seen that before when three officers. Certainly, the licensee has a right to examine those officers because they're certifying officers, correct?
They do get that opportunity at the administrative hearing. And if they wanted to get these officers to testify, then they could have subpoenaed those officers themselves on their behalf, because the state has argued that we subpoenaed the witnesses. We could release those witnesses. We are not beholden to what the other party needs for their case.
Well, counsel, you aren't going to say if you make an agreement with counsel, then you can later break that agreement and say, well, I'm not going to bring my witnesses in then.
Well, I simply stated that I would subpoena them. If they don't show, I can still release them. And that is something that occurs, I believe, in many cases at trial where witnesses will be subpoenaed, but can be released from the party that has subpoenaed them.
Do you have any authority for that? I mean, I'm not.
For releasing.
Well, some case authority or rule that says the party on behalf of whom the subpoena is issued can release the subpoenaed witness?
Not off the top of my head, Your Honor.
Well, I kind of hunted around and I'm not sure I find it. I mean, the subpoena is issued by the clerk of the district court, correct?
Yes, and in this case, the subpoena stated that these witnesses would be testifying on behalf of the defendant.
You identified them to the court, though, that they would be there to testify.
Yes, I stated that I would subpoena them and serve them, and that's what I did at this case.
And I don't want to get hung up on, I mean, I think the agreement specific to this case is a factor here. But I'm more interested at the moment in focusing on the argument that the party on whose behalf the clerk issues the subpoena has the authority to release the witness from the subpoena. And I'm not sure and And neither side has cited any authority for that proposition. They just sort of said, well, okay, I'm not sure I get that. I mean, because the subpoena is actually issued by the clerk of the court as an officer of the court. What authority does either side have to release somebody from an order to appear that's issued by the clerk?
I would say I would argue that because the subpoena states that this witness is testifying on behalf of the Kansas Department of Revenue for their case in chief, then it would make sense if I were to release that witness even before trial occurred.
I understand that would make sense, sort of, but you're countermanding an order that's issued by an officer of the court who is somebody else. I mean, do you actually have that authority?
I cannot.
And I'm trying to figure out where it comes from.
I don't, off the
It
top of my
seems
head, I do not.
sensible, kind
Yes.
of. I mean, it does, and practical, but I'm wondering what the basis for it is, other than people assume they can do it.
If the court would allow me to brief this issue
Well,
more
if you can
afterwards, then
find
I
something,
can.
I mean,
otherwise.
I'm going to ask Mr. Mayfield the same thing, and he says it's a. Well, go ahead. No, I mean, I
I want you to get back to my question. What did the court do wrong?
The court didn't, I believe they acted, their action was an abuse of discretion because here they had a witness that showed that was an officer that did sign the DC-27. They didn't even allow the DC-27 facts to come in, even though statutorily the DC-27 does come in. But by not even giving the opportunity for that witness to be heard, in my brief, I stated for collective information, that means that the officer using their information that they had from that case he signed the DC-27, he was a part of the investigation, the collective information of the police officers could have come in.
It seems to me, counsel, there's a two-stage process here. First, you have the administrative hearing in front of a hearing officer of some sort. And then you've got a trial de novo. What does that mean to you, a trial de novo in district court?
I believe what it states, it's a trial that it would allow new information to come in, because at the administrative level, there are only certain objections that a licensee can make. And so at the district court level, those, for instance, constitutional issues could be argued in district court.
So for somebody to lose their driver's license, there's two steps. And you can choose not to appeal to the district court after you've had your first hearing, correct? But you have that right to a second, but the burden turns to you. Licensee,
Yes.
correct?
Correct.
And if the officers don't show up to that, you lose.
I wouldn't necessarily say that you lose.
So all an officer has to do is not show up, like two didn't here at trial, and the licensee is going to lose because their witnesses aren't there. Do you see the dilemma
Yeah.
that's being created here? You're giving an incentive to the officers not to appear, because then their side will prevail because they aren't there unless the licensee subpoenas them.
Well, the licensee could also testify to what occurred at that event for them to have been arrested. And so they can't bring no evidence to.
They're not obligated to testify.
Yes, they're not obligated, but that's an option for them to testify. They could have subpoenaed the witnesses themselves. They have the DC-27 to put into the record for if they would have liked to argue
So
anything.
you're saying the licensee should not rely upon the Department of Revenue's assertion that they're going to subpoena the witnesses, or promise or agreement.
Well, yes, I would state that it was a courtesy for Because when I do file the subpoenas, they are on notice that subpoenas have been filed. When I serve them, they are on notice that they have been served. They're on notice of what the subpoena states. And these subpoenas all stated that all of these witnesses that were being subpoenaed were on behalf of the Kansas Department of Revenue. If they
The
had
subpoenas
wanted,
Are they in the record on appeal?
unfortunately, I thought they were. After checking it again,
I couldn't
the
find.
only subpoenas that were in the record were from the administrative hearing.
Okay.
I'm not sure if I'm allowed to supplement now.
Ms. Nguyen, I did have a question though. When you subpoena the witnesses, and then when you're going to trial, do you submit a list of witnesses to the court?
Only if the court asks. And so I don't believe this court asked.
Some courts do.
Yes.
Some courts don't.
Yes.
What the court did here essentially was impose a sanction on the Department of Revenue for the failure of the officers to obey the subpoenas, correct?
Yes.
And does the district court have the authority to do that?
I don't believe so. And I would also state that the appellee's brief had stated that the licensee's due process rights were violated. But I could use those same arguments to state that Department of Revenue had no ability to even show any evidence in this case. And therefore, it was in actuality the due process rights of the Kansas Department of Revenue that were violated, given that
Well,
we could not
okay,
show
but
anything.
But
at
that's,
trial.
I'm sorry, I didn't mean to interrupt you. That's premised on the notion that the district court has no authority to sanction what it believes to be misconduct is too harsh a word, but I mean, the officers as agents of the state failing to appear in response to a subpoena. And you're saying that the court doesn't have that authority?
To sanction us for our witnesses not complying with subpoena, I would say that the district court would have the ability to put in the witnesses into contempt, but for one of the parties to.
Well, that is an option, but KSA 77 622B clearly says that the court can dismiss this, couldn't it? Why wouldn't that statute apply?
I believe that, I can't think of 62 section D off the top of my head, but I would argue that in this case, it wasn't what the district court should have done. The district court had evidence that it could have listened to. In the transcript, it states that it realizes that it could take the DC 27 into consideration. It could take.
So you're just saying
officers.
that the sanction was too harsh?
Yes, I would argue that it was too harsh. If the district court has that ability, then this should not have been what the option that was chosen.
You, any other questions?
No. I'm
Thank you,
sorry.
Ms. Nguyen. That's your time for now.
Thank you, Your Honors. I really want to address three issues. And I really think that the whole subpoena issue, I want to address it briefly because you've raised some interesting questions that I had a problem with when I was trying to write the brief for this. The second is really about the due process. And I want to just get out early and say that I'm concerned about the word about sanctions, because I don't think this is about sanctions. I think this is about due process. And it's what's afforded from Ms. Schrand when she brought this case. And the last was whether
You ought to
there's
watch
a
what
proper
you ask
release.
for here, but that's all right. It's up to you.
Yes, Your Honor.
Let me turn to the mundane, which is the subpoena stuff. Are you aware of any authority that allows an attorney to release a party from a state subpoena that is issued on the attorney's request by the clerk of the court? And I have to admit, most of my practice was in federal court, not state court. And it's I think a different kettle of fish over there. But I mean, is there authority, or is it that, I mean, if you're the party that asks for the subpoena to be issued, you can release a party or release the witness?
Your Honor, I've probably been in trial with 1,000 witnesses in my practice. And I seem to recall in almost every occasion, a judge says, may this witness leave today? Is this witness free to go?
Well, and I think that it says once you get there, but what about beforehand? I mean, you've had the subpoenas issued to these witnesses and you decide you don't want them. I mean, they're redundant or whatever. You have the authority then to countermand the order of the clerk reflected in the subpoena and call that witness and say, you don't need to show up.
Well, my argument, I can't find any case law on it, but my common sense tells me that if you send the invitation to the party, you got to send the invitation. You don't have to come to the party, meaning the clerk or a judge who has authority to issue a subpoena should be the one to release it. In fact, when you go to receive service and you're not able to make it, you're actually clerks won't let you issue another subpoena until you file a non-S that you were unable to serve that subpoena. So,
Counsel, there's another aspect to that question too, isn't there? Even if you could release somebody that you have subpoenaed in, if you know that the other side is relying upon your compelling that the witness coming to the court, then you at least ought to notify the other side, shouldn't you, that you're releasing that witness?
That's interesting, Judge, because you're talking about professional courtesy, and sometimes we've lost focus on sometimes about what role professional courtesy plays in our judicial process. And I was prepared to say essentially that we've taken our gunfights off of Main Street to allow courts to make decisions. We allow judges to do that, and attorneys aren't opposing each other. While that may appear to be that way, we're actually workers in the process, bringing evidence for the court to make a good decision. A subpoena is exactly one of those tools that we work together. We might work out who should be subpoenaed, who does the laboring order to get the information before the court, so the court can make a fair, just, and equitable decision.
Beyond the courtesy, though, when a subpoena is issued by the state, how are you notified about that?
Well, it's actually, I don't want to get caught up in too many of the weeds, but the letters, I sent letters in both the second hearing and the third hearing, asking and confirming that those subpoenas, because that was my job too for my client, those subpoenas would be issued, and according to counsel's indicating it would. The court's clerk indicates when subpoenas are issued from the court clerk. It's on the docket.
You receive notice.
Oh, yeah, of course.
Right.
And we know that.
And so then should a subpoena be withdrawn, canceled, etc., that would then also go to the clerk and you would receive notice of that.
Yes, Your Honor, of course. And that was my comment on the subpoena non-S, if you weren't able to serve it. But even next step on courtesy, hey, I couldn't get a hold of these guys. Well, okay, then let me try again or approach the court and ask for continuance, because it gets back to due process again.
Now, counsel, you're an experienced advocate. You've been through this any number of times. You protect your client, don't you, by subpoenaing witnesses, whether the other side has or not?
I don't, Judge. I mean, I shouldn't say I don't. If I don't trust an opposing attorney or think there's some skullduggery in the process of the witnesses, of course I would. These are law enforcement officers that are expected to be there. What the record won't show is that in the first hearing, the judge called the police chief and said, hey, why aren't these guys here? And we sat there for probably half an hour trying to track them down and couldn't do it. So he went ahead and continued that first trial. And the court really kind of said, well, you're going to request it. It was said there, but there was no record of that hearing. But it
is there any element of that in the third setting?
When you say,
did that give any motivation to the court to go ahead and dismiss because those three didn't appear at the first?
Yes, Your Honor, of course. And this court had very, very active knowledge of the facts and circumstances, even though my client was arrested 4 years ago. And the first trial was maybe 2.5 years before that. And it's not, COVID slowed things down. But this particular hearing, and there was one particular officer, and his name was Kenny Garrett, and typically has very extensive involvement. In fact, these two other officers called him as a backup And even the judge said on the record, well, I don't know how you can make the case without Officer Garrett, and he's not here. And it's because he was an important witness. And he was why I put in my letter to counsel, be sure to ask Officer Garrett to be there. And I expected him, and I needed him to be there. And the court asked for some proffered testimony, and of course I indicated the importance of this particular officer who didn't appear.
77-622B
Yes, Your Honor.
is the statute that interests me in this particular case.
Yes.
What do you think? You're familiar with that statute? Does that give the court authority to dismiss?
Of course, Judge. The Administrative Procedures Act that kind of governs all of this is pretty broad in what can and can't be ordered, and what would actually satisfy an abuse of discretion. And it's pretty broad and gives the court extreme latitude. And it specifically says to set aside and modify an agency action. Dismissing an agency action is one of those, that's a relief the court certainly has available to it.
Doesn't that statute though deal principally with the merits? I mean, you never get to the merits in this case. I mean, that's not why it was dismissed. It had nothing to do with the merits.
I disagree, Judge. I think that the statute.
Which part of that?
Well, the part that says that really it's only about the merits. This is also about process and procedures. And in the Manzano case, and actually before that, the Kempke case, we talk about it being a two-step process. And if the second step isn't there, and I'm trying to think of some really fancy analogy, but I'm thinking of like a baseball analogy where what the state's arguing is that, well, they didn't bat right, or they didn't hit a home run, or they had a strikeout. And what I want this court to know is that what we're really talking about is he never got in the stadium. He didn't get a chance to even bat. He didn't even get it, or, my client did not get a chance to have her hearing. And so I don't want to put too much emphasis on who's sanctioning or who's getting in trouble. It's really about when's enough. And one of the,
Well, that's the point, and that's why a court has authority to sanction by dismissing.
well,
It's enough. Now, and the question is it enough?
well, when you say, is it enough? I mean, we need to remember this whole process. It's a two-step process, but it's actually a taking. My client was the one on the losing end, I suppose, the one whose status quo is being changed. And to say,
I know, I'm not sure I understand quite why you're fighting with me. I'm suggesting that the district court probably had the authority to dismiss as a sanction here because the officers didn't show up. And you're saying no?
no, of course they did. That's what
Okay.
77-622B really affords. And
Well, even if it doesn't, the court has don't you think the court has the inherent authority to do that?
oh, I think under the ideas of due process, they would, sure. But statutorily, they absolutely do, because that was the nature and extent of the process that we were before the court in the first place. So I'm an administrative appeal. And maybe I don't understand your question.
Well, no, I'm not sure I understand your due process argument, actually. I mean, I'm not sure how there was your client would have been denied due process if the hearing had gone on and it had been even bifurcated to get the other witnesses in later or something. I mean,
Well-
I'm missing how it's a constitutional violation here.
Somebody asked,
If the judge had gone forward in some way, I
Well,
guess.
KSA 81020 really sets up what all the scope of appeals might be, both administrative and on a de novo appeal. And all of them say, yeah, okay, it's a burden of proof. And I would tell you, I had the honor of being a hearing officer for the Department of Revenue for about, I don't know, 14 or 15,000 of these hearings over 12 years. And I can tell you the burden of proof is absolutely on the driver at these administrative proceedings when we get to the de novo appeal or the administrative proceeding, both of them. But you can't present your evidence. The due process argument is that I'm allowed an opportunity to present at a meaningful time in a meaningful place the evidence that allows me to defend that. And the Manzano case, both and the Kempke case, both kind of speak to that. And if the officers don't show up, a meaningful defense at a meaningful time is not possible. And the judge, somebody asked, well, what could the judge have done? And the judge could have continued it a fourth time, maybe a fifth time, maybe a sixth time. And at some point, the judge has the discretion under 77-622B to say, you know what, this person's due process is not being afforded. They're not being allowed to present the evidence they're otherwise entitled to present. So hopefully that addresses the issue about concerns about due process, because I think it is a process and it's a two-step process. The administrative hearing, which was the issue in Manzano, but also all those cases talk about the importance of having the second hearing. And if properly subpoenaed officers, important to the driver's case, aren't there to provide that support, that's not a meaningful opportunity to be heard at a meaningful time. And those are the fundamental issues of due process that I think all drivers would be afforded before their privileges to drive in the state of Kansas were removed. So if anybody has any additional questions, I'm happy to answer them, but I appreciate your time.
Thank you, counsel. Ms. Nguyen, you have 4 minutes.
Thank you. May it please the court. I would just state that under 70 KSA 77621, which was quoted in my brief, I don't believe that the district court had any ability to actually follow what the KJR says under that section, which would grant relief to the licensee. Because
621 is a specific statute, correct?
yes,
And that is clearly, if the court is going to make a ruling upon the merits, it's going to have to make a finding on one of those.
yes,
What is there, 6 or 7 subsections in there?
eight, I believe.
Eight subsections. The court's going to have to make a finding on one. And the court didn't do that here.
Yes,
But the court didn't address the merits of this one bit,
yes.
did it? So the question is, does 622B, which clearly says you can dismiss this, does that trump those? Why? In other words, if there is no hearing on the merits, does the court have to comply with 77-621?
I believe that because there were no merits in this case that were put on the record because the trial never happened, then possibly no. However, I would state that 77-622B, even though it says that the court is allowed to dismiss a case under their discretion, I would say that this court tried to shift the burden of proof from the licensee to the state of Kansas by sanctioning the state of Kansas when their own witnesses chose to not appear for whatever reason, we still don't know. However, because there was a witness there, and in my brief, there's the collective information that officer could have been a witness, and from what he had known of what the other officers did, he could have testified and been able to answer any questions that either party
Can I ask
had.
you this? If the licensee had subpoenaed the witnesses, the officers,
Yes.
and they had not shown up more than once, would it have been appropriate for the court to dismiss as a sanction?
I would state because they have the burden of proof, they wouldn't have been able if they needed those witnesses to show and they had subpoenaed them and they didn't show up multiple times, that yes, possibly under the discretion of the court, that would make sense.
Because they needed those witnesses for their case.
Yes.
So
to-
your
to
only
meet their burden.
contention then is because the subpoena issued from the state, then they're not allowed to rely on those witnesses.
I would say that they should have separately subpoenaed those witnesses if they were so essential to their case. And they needed to rely on the subpoenas that had already been issued. And the opposing counsel and I have had many of these cases together. And he did state in his argument that he doesn't subpoena witnesses that have already been subpoenaed. But I would state that I've had cases where I'm not sure if it was him or other
I'm sure it
attorneys, but
happens. I'm sure sometimes subpoenas issue from both sides for a
Yes.
witness. I
and-
don't
and-
know why that would be necessary. If you have a clerk of a court telling you to appear, why you would need both sides to tell you to appear, but okay. If you had released the witnesses prior to trial, would he have been notified? And then able to issue his own subpoena?
I can't speak to that because I've never done that unless it was before trial, then I would have released them. I've never been sanctioned for releasing a witness that I have subpoenaed.
But
Again,
you
I'm
don't know if the other party receives notice that that witness is released from their subpoena.
not sure, Your Honor.
Could I ask you, is it general practice, does the ADOR agree to issue the subpoenas for officers in the trial de novo on a license revocation? Is that the common practice?
For my common practice, I typically subpoena the officers because I believe that they would actually help my case more than they would help the licensee's case. Because it gives the supplemental information.
I guess along with that, is it the common practice or understanding that the licensee then does not need to issue a separate subpoena? It
No.
replaces that.
No, I don't believe that it would replace because essentially if we were told, if we were made, like if this court allowed this to happen in every single driver's license case such as this, then I would state that it would actually shift the burden to the Kansas Department of Revenue to provide evidence.
Well,
And
read just a subpoena the witness. I never did these kind of things as a lawyer, so I'm understand how they operate from looking at these cases, but it's kind of like the wise men and the elephant. I'm seeing a very small part of it, and I'm not sure I see the big picture. It seems to me Department of Revenue would have some benefit in agreeing to subpoena the witnesses, so you don't have lawyers for the licensees hiring private investigators to track down the officers either on duty or at their home, and in the middle of the night handing them subpoenas to show up. But that's not particularly desirable, and that could be headed off if the Department of Revenue agrees to subpoena the witnesses and it's binding on both sides. And I'm just asking, is that the common practice or isn't it? I don't care whether you do it or don't do it. I'm just trying to figure out if that is what's done.
I know that from my experience and from other attorneys I've spoken to that are my colleagues at the Kansas Department of Revenue, we typically subpoena the officers to help our cases. We don't subpoena them to,
Well,
because-
I understand. We're going,
because it's
now we're kind
easier,
of going in
yeah.
circles, but in doing that, do you then tell the other side, you don't need to subpoena them, I'm doing it, or I've
I
done it?
don't.
Okay.
Because when I do subpoena the officers, they do see that my subpoena says on behalf of Kansas Department of Revenue.
Well, we can't guarantee how they're going to testify. Though. The question is just getting them there.
Yes.
We're not going to presume that they would have completely won your case for you.
Right.
So the issue is just how we get them to the court and who's notified about that. So I understand that the subpoena says, on behalf of the state, but I don't think that's relevant.
Okay.
Because we're not guaranteeing that they're testifying. to
Yes,
help.
yes, I understand, but I would,
Leave about a minute
okay, and
just to wrap it up.
thank you. And I would argue that, given that the licensee had the burden of proof here, and from what my brief has stated, there needs to be reasonable diligence for them to provide evidence. Here, they did email me and state, hey, could you also subpoena another witness since you're already subpoenaing them? And as a courtesy, I said, yes, I will. But if they know they need those witnesses for their case, as they stated at trial or in their motion to dismiss, then I would argue that if they were so essential, then why did they not meet their burden of proof by subpoenaing those witnesses themselves and making sure to contact those officers that hadn't showed already at one of the other settings? What why is it the Kansas Department of Revenue's responsibility at that point and sanction that only the Kansas Department of Revenue can make these witnesses appear? And so I would just state that I would like the court to review all my arguments made in my brief and ask the court to remand this to trial court. Thank you.